Have you ever wondered how lawyers dig through someone's past and decide what a jury gets to hear? Well, today we're going to break down a really cool piece of legal strategy. We'll see how a criminal record isn't just a list of mistakes. It can actually tell a story that can make or break a case.
Okay, let's jump right in. Meet our two defendants, Susan Berry and Peter Goldsmith. They're both charged with the same crime, but their stories couldn't be more different. She says she thought he had a right to grab the package. He says, no way, she told him to get it and said it was just some stuff from a friend. This is a classic he said, she said mess, or what lawyers like to call a cutthroat defense. They're both trying to save themselves by blaming the other.
So let's set the scene. It's December 19th, 2025. A cop on patrol sees something fishy. He sees Peter Goldsmith jump out of a car, run to the doorway of a video game store, snatch a parcel, and then dive back into the car. And who's behind the wheel? Susan Berry. And what's in that parcel? 20 shiny new PlayStation games. The facts of what happened seem pretty simple, right? The stories, though, not so much.
And this creates a massive headache for the prosecution. You've got two defendants, and they're both pointing the finger directly at the other one. So if you're on that jury, what are you supposed to do? How do you figure out who's telling the truth? This is a huge problem that has to be solved before a trial even makes sense.
This is where the prosecution might pull a very specific tool out of their legal playbook. It's a way to bring up a defendant's past, but it's super powerful and, because of that, heavily restricted. It's called bad character evidence. So, what is it exactly? Well, bad character evidence is basically any proof of someone's past misdeeds that aren't directly related to the crime they're on trial for now. And courts are extremely cautious about this stuff. Why? Because there's a huge risk that it will unfairly prejudice the jury. The big fear, and this is a fear that goes back centuries in law, is that a jury will hear about a past crime and just think, well, if they did it before, they probably did it this time, and totally ignore the actual evidence.
Now, trying to get this evidence into a trial isn't some kind of surprise gotcha moment like you see in the movies. It's actually a very formal, by-the-book process. First, you have to file a notice saying you want to use it. Then, you serve that notice to the court and everyone else involved. And critically, the other side gets 2 weeks, 14 days, to fight back and argue why the judge shouldn't let it in.
So let's see how this plays out in our case. The prosecution wants to look at Peter Goldsmith's criminal record. But the goal here isn't just to say, hey, look, this guy's a criminal. No, the goal is to be a detective, to look for a very specific pattern of behavior that might just tell us what was really going on that day.
All right, here's the whole shebang. Goldsmith's entire criminal history. It's a bit of a mixed bag, right? We've got criminal damage from when he was younger, a couple of thefts, a serious burglary, even failing to show up for this very case. But here's the thing. Not all of this matters. The prosecution has to be surgical here and pick out only the convictions that tell a specific story.
Let's start with a theft conviction from way back in 2015. On the surface, it seems pretty minor, but it's the first time we see a key element pop up. He wasn't working alone.
Now really picture this scene. The detail is what matters. Goldsmith is the one pushing a pram with a baby in it, but his girlfriend is the one security guards see putting stolen items, coffee of all things, into that pram. See his role? He wasn't the main actor. He was helping, playing a supporting part.
Okay, let's fast forward a few years to 2019. This time, it's a much more serious crime, aggravated burglary. But again, we need to zoom in on his specific role in it.
And this is huge. It's the smoking gun for the pattern. The judge in that case literally spelled it out. Goldsmith wasn't the mastermind. He was just the lookout. He'd been pressured, he didn't help plan it, and he didn't even get paid for it. He was, in every sense of the word, a subordinate.
Let's look at just one more, from 2022, another theft. This is the one that really hammers the point home. And there it is again, the exact same kind of behavior. He's not the one grabbing the goods off the shelf. He's making a scene, creating a diversion so someone else can do the actual stealing. His role is always secondary.
So when you line up these specific cases, a really clear picture starts to form, doesn't it? Peter Goldsmith has a distinct pattern when he commits crimes with other people. He's almost always the supporting player. He's the assistant, the lookout, the distraction, and very often there's this suggestion that he's just following orders.
Okay, so you found the pattern. That's a great piece of detective work. But how do you take that analysis and package it into a formal legal argument that a judge is actually going to buy?
What's really interesting is that if you look at how these legal applications are graded, it's not just about knowing the law. Look at that. 40% is for knowing the law, but another 40% is for the quality of your reasoning. It's just as important. It's all about how you connect the dots. So let's see how it's done.
It all starts with finding the right legal tool, which in this world is called a gateway. It's basically a legally defined reason for letting the evidence in. And the gateway we're looking at says the evidence is allowed if it has substantial probative value. That's just fancy legal talk for it's really, really relevant and helpful. And helpful for what? For deciding an important issue between two co-defendants. It's like this rule was written for our exact situation.
So here's how the prosecution puts it all together. Goldsmith's defense today is, I was just doing what Barry told me to do. His criminal record shows a clear, established pattern of him, well, doing what other people tell him to do during a crime. Now, this doesn't automatically prove he's guilty this time, but it makes his story that he was just the follower a whole lot more believable. And it makes Barry's story look a whole lot less convincing.
So, what's the big takeaway from all of this? This whole process, this application, it's not just about filling out some paperwork. This one single document has the power to completely change the entire dynamic of the trial.
The prosecution's entire theory of this case is that Susan Barry was the director and Peter Goldsmith was her junior partner. Without his criminal record, that's just an accusation. It's their word against his. But with that evidence, it becomes a compelling story, one that's backed up by a documented history of behavior. It gives the jury a logical reason to believe one person over the other.
And all of this leaves us with a really deep and fascinating question that courts have to wrestle with every single day. The law is trying to walk this incredibly fine line between using someone's past as a legitimate clue to their behavior and just unfairly branding them for past mistakes. So where do you think that line should be? When does a story about someone's past just become a label they can never escape? It's a tough question with no easy answers.